All rise. Judge of the B Court is now in session. Judge, this is case number JVB 1039, Sutton case.
Thank you.
You're welcome.
Okay, Ms. Sultan, you're back. And I see that you got, well, dad or potential father served. What's your name, sir?
My name is Stephen Pippin.
Mr. Pippin. Okay. You understand why you are here today, right?
Yeah, unfortunately.
Okay. You know I ordered you to have DNA testing done a month ago.
Yes.
And so we can determine child support, what it's going to be in this case. And I don't have anything from the testing center showing that you showed up. So what's going on with that?
Because I didn't take it. I mean, I don't know what she's talking about.
So I order you to do something. This is not about her right now. I order you to do something and you just decide on your own, I'm not going to do it?
Yeah, I mean, I don't think I'm the father, so I don't have to take the DNA test.
All right, folks, buckle up. This child support case is heating up. Miss Olin returns to court, and this time, she's brought along a potential father, Mr. Stephen Pittman. Right out the gate, the judge gets straight to business, asking why Mr. Pittman still hasn't taken the DNA test she ordered over a month ago. His excuse? He says he's been too busy and doesn't believe he's the father anyway. The courtroom gets tense as the judge makes it clear. Excuses won't fly. Accountability is coming, and fast. Let's see how it all plays out.
Well, if you don't think you're the father, wouldn't it make sense to go ahead and take the DNA test?
Yeah, but I mean, it's all this long process. I'm a busy man. I got a lot of stuff on my plate right now, so I don't have time to sit back and
Well, how busy are you? What do you do?
I'm a waiter.
Oh.
And I'm a full-time student.
Oh, okay.
So I don't have time for the games and all this testing, DNA testing, all that. I don't have time for it.
All right, so you work every day as a waiter?
Yes.
Did you bring anything today to show that you're waiting tables? Any type of financial information?
I ain't bring that.
Oh, so you didn't care about that either. So did you bring anything to show that you're enrolled as a full-time student?
Nah, I ain't bring none of that.
So you just came to court unprepared today and you just think I should go along with that, right?
I mean, if that's what you want to call unprepared, yeah.
When did you start working as a waiter?
About 4 months ago.
What did you do 4 months ago?
I had a full-time job working as a consultant.
All right. How much money were you making?
$63,000.
Hold on. How did you say your baby was?
5 months.
5 months. And you just stopped working there 4 months ago?
Yeah, they had some layoffs, and I kind of thought that they were going to start laying some people off, so I decided to go ahead and quit.
So you quit? Mm-hmm. You didn't quit because you figured she was probably going to put you on child support?
Nah, I just...
Are you sure about that? Because it's mighty funny that this child is 5 months old and you just stopped working that job 4 months ago. How much money were you making?
$63,000.
$63,000 a year? And you're making how much as a waiter?
I did it because I'm a student, so I'll probably make around $15 an hour.
Oh, no. You came here to waste my time. You obviously came here to waste my time today.
Mr. Pittman's defense? Not exactly convincing. He admits skipping the DNA test, blaming his packed schedule as a waiter and full-time student, but the judge isn't buying it. Especially when he can't show any proof of a job or school enrollment. Excuse after excuse piles up, and it quickly becomes clear he's dodging responsibility. Then comes the bombshell. Mr. Pittman left a $63,000 a year job just 4 months ago. Now the judge isn't just skeptical. She's questioning his entire motive. Things are about to get real.
I am not going to place you on child support for $15 an hour and you just start working a job paying you $63,000 a year. You see how crazy that sounds?
I mean, I think it's crazy that you using my $63,000 income. I don't even work there no more.
You don't have to work there, but it sounds like you intentionally stopped working there because you thought she was going to put you on child support.
No.
So you just disappeared on her?
Because I'm not the father. Like, I don't even know. Like, I'm at work.
But we don't know that you're not the father because I ordered you to go and get DNA testing. So we could have found that out today. But you know what? We don't have to do it. You know why? Because I can deem you the father today because I ordered you to do it and you didn't do it. That's what we're going to do. That's exactly what we're going to do. So, who carries health insurance? Well, never mind. That was a bad question.
Yeah, it's me.
You carry health insurance.
Yes,
How
ma'am.
much is it?
$750.
$750. Does that include you and the child?
Yes, it does.
Okay. So what I'm going to do is split that in half, because child support, his obligation, he's only responsible to pay health insurance for the child only. Okay. So based on $63,000 a year, I have your monthly gross at $5,250. That brings your net to $4,226.99. How many other children you have? No other children?
other children.
Well, I hope not. I hope you're not ghosting on them either, because that's exactly what you did to her. So I have your monthly child support obligation at $845 plus $375, which is half of that $750 for health insurance for the child. Your monthly obligation is $1,220.
The judge doesn't hold back. She calls out Mr. Pittman for intentionally quitting his $63,000 a year job, likely to dodge child support. Despite his claims of being a student and a part-time waiter, the judge isn't swayed. She bases his support payments on that former salary, ordering him to pay $1,220 a month plus half the child's health insurance. And since he ignored the DNA test, he's declared the legal father by default. No more excuses. A firm, fair ruling and a clear message. You can't run from responsibility.
And I'm ordering you to do that. And you don't have any control over that, because that goes through a state agency and it'll just
I'll
withhold
just
from you.
go ahead and just submit my W-2s whenever I get them. I'll come back.
Oh, okay, that's fine. But today, this is what we're doing. Since you came in here unprepared and not caring about anything, you don't care about that $1,220 either then, right?
Okay, I guess so. But we'll get up there. I'm not tripping.
Okay, well, we can do that at a later date. Do you have any other questions?
No, I don't got no question.
Okay, do you have any other questions? Okay, if nothing further.
Mr. Pittman is clearly frustrated by the judge's ruling, but she doesn't flinch. She reminds him that court orders are not optional, and his failure to take the DNA test means he's now legally deemed the father. The judge sees through his excuses, from quitting a high-paying job to skipping the test, and makes it clear, this case isn't about his comfort, it's about the child's needs. Under Texas law, refusing a court-ordered DNA test can result in being declared the father by default. And with that, Pittman is ordered to pay $1,220 a month in support, including half of the child's health insurance. Before closing the case, the judge delivers a stern message. Parenting is a responsibility, not a choice you make when it's easy. The episode ends with a reminder that every decision made in court affects a child's future, and accountability is not optional.